Thank you for joining us. Could you please tell us your name and professional qualifications?
Yes, my name's Dr. Bruce Lindsay. I'm a lawyer with Environmental Justice Australia. I've got qualifications in law, both undergraduate and postgraduate, a PhD in law. Also relevant to this exercise, I have a Masters of Environmental Science.
From your professional viewpoint, could you please provide an overview of the legal system governing the Murray-Darling Basin today?
Yeah, so if I could take you to the slides, what I'd like to do is go through these slides, and hopefully that provides a broad overview of water governance in the Murray-Darling Basin. And I've got one slide at the end in respect of the Darling in particular. So I want to take people through the issue of water governance in the basin. So if we can go to the first slide, there's simply a representation of the Murray-Darling Basin system, which is probably quite familiar to a lot of people here. The basin system is, a large catchment, and contains many subcatchments that runs from Queensland through New South Wales, the ACT, Victoria, and into South Australia. Broadly, the system drains from the west of the Great Dividing Range, or the north in Victoria, through the Murray system, and joins with the Darling system around Wentworth, and then drains through South Australia down to the Coorong Lakes in South Australia. So that's the geographic area that we're dealing with, and the regulatory framework, the governance framework we're dealing with covers this geographic region. The next slide I'll take you to, I think, deals with sort of some of the context that we're dealing with in the Murray-Darling Basin, to which governance questions relate, or why they've arisen in the form that they have. So the Murray-Darling Basin system is the largest agricultural producing catchment or system in Australia. It's very productive in that sense, but I think we can probably describe the system as being affected by widespread industrialisation. So we call this industrialisation of the Murray-Darling Basin. This has led, in particular, over the last century or more, to extensive modification of the eco-hydrological systems in the basin, so both the ecology and the hydrology of the system. And as you can see by some of these pictures, that modification has been in the forms of constructed works, dams, weirs, and so forth, extensive extractions for irrigation, and also town water supply, and so forth. There's been quite considerable drainage schemes and so forth. So I think first thing to bear in mind is that the system that we're talking about in the basin is highly modified, especially by large-scale engineering of the landscape. I think further points that are important to note in this industrialisation and modification are the extensive clearances, if we can call it that, of First Nations through the 19th century in particular. There's large, widespread populations of First Nations people throughout the region. There still is tens of thousands of First Nations people live in the basin, but of course their livelihood and way of life are extensively disrupted through the 19th and 20th centuries in particular. There's large-scale settlement in the wake of that, including by after the war soldier settlers. Water law in this context and water governance has been a real important facilitator of that modification and industrialisation of the landscape. Consequences of that dynamic have been very profound on the basin landscapes. In particular, and partly the reason why we've come to a situation of federal intervention in governance of the basin is there's been extensive large-scale over-extraction of water resources in the basin through the 20th century, and this became particularly evident in the so-called millennium drought in the 2000s, where there was widespread extraction or over-extraction of water resources, leading to the crisis and imminent collapse of various ecosystems in the basin. If we can go to the next slide, in addition to simply there being no water, the other ecological consequences of over-extraction and industrialisation have been eutrophication events, large-scale salination of land, and so forth. So widespread ecological disruption, which has led to both ecological problems but also productive problems for industries like agriculture. I'll come to the consequences of that as a legal responses to that in a minute. But I think, first of all, before we go to that, it's important to consider how in Australian law water is managed. Primarily, what we're talking about in this presentation is the laws relating to water resources and water management. Importantly, in Australia, there are sort of constitutional dimensions to water management and distinctions between federal and state jurisdictions within a federal system. The Australian Constitution provides for limitations on the Commonwealth's role in water management. So the Commonwealth, as this slide indicates, under Section 100, shall not by any law or regulation of trade or commerce abridge the right of a state or of the residents therein to the reasonable use of waters or of rivers for the conservation of agriculture. The consequence of this is a continuation from the colonial period of states having primary responsibility for water resources management. That's particularly important in terms of the allocation of rights to take water and control water resources. It's also been an important control or limitation on the Commonwealth being involved in this space until 2007 in a legal sense. So if we could just briefly look at the state's role in water management, because it's particularly important if you're looking at the Murray-Darling Basin and also irrigated agriculture and that kind of production in that system. First of all, in general, there's some sort of underpinning dimensions to state water law. All jurisdictions in Australia, including those in the basin, have water statutes that control and manage water resources within those jurisdictions. First of all, we have inherited and brought into the statutory form or into legislation a distinction essential to English law is that the separation in legal terms of water and land as resources. This is very important in terms of the way in which water is managed and rights in water are vested. Secondly, as a departure from the English system in the 19th and 20th centuries, the Crown or state governments acquired through statute, through legislation, the primary right to water. So the Crown is the primary, water is vested primarily, or in the first instance, in the Crown, and then the Crown via ministers, water authorities and so forth, grant rights and interests in water to take or store or construct works over it. So that's in the form of all sorts of different instruments, water entitlements, water licenses, other types of water rights, for instance. And those are essential to the management of who can take water, how much water they can take, when they can take it, and so forth. The management of water resources over the last 20 or 30 years has also been subject to various forms of statutory water planning. And this has been a very important response to the ecological constraints and limitations of the use of water resources in those various jurisdictions. What water planning is called in different jurisdictions can differ, and the instruments to do it can differ. And water planning is also a very important phenomenon, as we'll come to at the federal level now. Finally, planning and decision-making in respect of water planning and decision-making has increasingly been guided, at least in principle, by models of ecologically sustainable development. So it's the broader overview of the state's role in water management. What I want to come to next to inform the tribunal is the national role, or the now national role, or national intervention into water governance. So there has actually been a very long history of what are called intergovernmental agreements between the Commonwealth and basin jurisdictions in relation to managing water in the Murray-Darling Basin that go back to the early 20th century. These are largely political agreements, however, without legal consequences at the Commonwealth level. However, especially as a response to the ecological crisis and the over-extraction in the 2000s, the Commonwealth and the Howard government intervened and passed the Federal Water Act, or the Water Act 2007. This is a very important intervention. I'll come to some of the key elements of it in a minute. But it's important to bear in mind, given the point made about the constitutional constraint mentioned earlier, what were the constitutional bases for the Commonwealth to intervene in this context? There are a number of these, quite a long list of these, but the headline constitutional bases were the use by the Commonwealth of environmental treaties. The Commonwealth can legislate for matters relating to external affairs. So it used treaties like the Biodiversity Convention and the Ramsar Convention relating to wetlands as key tools or levers to intervene in respect of water management. It also negotiated with the state the referral of a number of important state powers in respect of water management as well. As I said, there are many other bases, but those are headline ones. The issue of environmental treaties is particularly important because in some respects it identifies or characterises the Water Act and the Basin Plan, of which I'll come to, as environmental statutes. And so there's an important environmental underpinning to the Water Act. So in terms of some of the characteristics or key elements of what is in the Commonwealth Water Act and what it's intended to do, there's some quotes here from extracts from provisions in the Water Act. First of all, the key sort of statutory fact that underpins the Water Act is a statement in there that use of basin water resources has had significant adverse impacts on the conservation and sustainable use of water. So that's kind of a premise on which the Commonwealth Water Act proceeds or has proceeded. And further, there's also the sort of purpose and principle of what the Water Act is intending to achieve in a broad sense, which is to promote the sustainable use of water resources. And as you can see, in terms of its protective and restorative functions of ecosystems, it very much reproduces the flavour of instruments like the Biodiversity Convention and the Ramsar Convention. So there's very much an environmental flavour to some of the purposes of the Water Act. In terms of key operational elements of the Water Act, a key mechanism is that the Water Act, through other instruments like the Basin Plan, which I'll come to, actually it will impose limits on the extraction of water to what are identified as sustainable levels. These are what are known as sustainable levels of take, and that is reflected in sustainable diversion limits. So they're effectively caps on how much water can be taken out of various water systems. In addition for that, there are mechanisms to provide for concepts or models of environmental water, that is water used for environmental purposes. So just in a bit more detail, go to some of the key features of the Water Act scheme. It establishes an independent statutory authority, the Murray-Darling Basin Authority. As I said, it establishes a scheme of caps on water extraction in sub-catchments and basins within the basin, as well as in the basin, Murray-Darling Basin overall. These are known as sustainable diversion limits. The intention of these, and it's highly politicised, settling on a particular number. So there's quantitative controls and limits on diversions, and these are intended ultimately. The diversion limit for the entire basin is around 10,000, a bit over 10,000 gigalitres a year, which requires or will require over a period of time the recovery of 2,750 gigalitres a year for the environment. But that 2,750 gigalitre target is probably one of the highly contentious points of what the Federal Water Act and Basin Plan scheme do, is to set that limit and that control. There has been increasingly or over time controversy also over whether the method for setting that number is correct in a legal sense, and that's been questioned recently in the South Australian Royal Commission into the Murray-Darling Basin. Environmentalists generally say the recovery number is too low, it should be higher, and irrigators, for instance, say the number is generally too high and should be lower. So it's a point of enormous contention and highly politicised. Within the Act also creates a detailed schema for legally binding water planning, and in some respects, in addition to quantitative caps, this nested governance framework is a central pillar or a central dimension of the Water Act framework. By nested governance essentially means that you have different mechanisms, legal mechanisms, undertaking the water management function at different scales, spatial scales, and doing so in slightly different detail. So the Water Act requires the preparation of what's called the Basin Plan, which occurred in 2012, which is a statutory planning framework for the entire Murray-Darling Basin, and sets that recovery target and sustainable diversion limits above. In addition, what it does, the Water Act and the Basin Plan require the preparation of 30 water resource plans, which are the more regional or localised planning instruments that will operate within particular water systems. There are 14 surface water resource plans and 16 groundwater ones. And these are to be completed by the middle of 2019. They were intended to be commenced in 2012, so there's been a sort of a long lead time in the preparation of these instruments. These instruments are quite crucial to the actual delivery of the overall sustainability goals of both the Basin Plan and the Water Act. They do the localised work of achieving sustainability, or the purported achievement of sustainability. There are sustainable diversion limits, as I said, with respect to the basin as a whole, but also each water resource plan area has its own sustainable diversion limit, which is an estimate in a quantitative form of how much water can reasonably be extracted or diverted from the water resources, from the rivers and groundwater and so forth from those areas. There has been processes put in place to adjust, in particular, limit the amount of water recovered for the environment, and this is what's often referred is what is called the SDL adjustment mechanism. Now, I won't go into the detail of that because it's highly complex, but again, it's been a mechanism, a highly politicised mechanism aimed at adjusting those quantitative caps or controls over how much water can be extracted from water systems, so from rivers and groundwater systems within the basin. Finally, and importantly, I won't go into it in detail, the Water Act establishes an environmental watering framework, including a statutory body called the Commonwealth Environmental Water Holder, who has specific type of water entitlements, known as environmental water holdings, which are used in order to achieve environmental purposes. So their flows held in storages and dams, weirs and so forth by the water holder that is used subject to environmental watering mechanisms or plans to achieve environmental purposes or outcomes, as distinct from consumptive ones like irrigation and so forth. So to go back and say that's the broad general governance scheme and legal scheme for management of the Murray-Darling Basin system. Within that scheme, I think it's important to distinguish how, say, different types of water is often understood in terms of the uses to which water is put. In terms of it's diverted or extracted or stored from particular systems within this highly modified and highly engineered systems. That is in order to use it for particular types of purposes. The use of water for what we might call industrial purposes, so that might be irrigated agriculture, it might be mining uses, it might be horticulture, those kind of uses. This is often referred to as consumptive uses. In addition, the extraction and storage and use of water for water supply for populations, town water, is also considered to be a consumptive use. So that's a particular set of the uses or the reasons why water is controlled. In many contexts, that is the largest single use of water within a particular system, especially where you have large-scale irrigated agriculture and large dams that are constructed for that purpose. There's other types of water uses. Often the key distinguishing one is what's called environmental uses. So where you have water that is either under plans or licenses or entitlements used to achieve environmental purposes, so to flood wetlands, for instance, or to stimulate breeding events of water birds or fish or things like that. They're considered to be environmental purposes. Now, I explain that because The last slide I've got here is, in some respects, relates to this particular circumstances of the Darling River, or the Barka, as it's referred to in local Indigenous language. It's also been a river that's been subject of particular controversy because of the level of take and the nature of industries on that river system. At the state level, as I've explained, the water arrangements operate in this occurs in respect of New South Wales, because the system entirely operates within New South Wales. Well, it's tributaries that operate in Queensland as well, but let's deal with New South Wales for current purposes. The Darling system is subject to what are called water sharing plans in New South Wales, also water access licenses. So both planning regimes and licensing regimes that permit and control the take of water out of this system. What has been particularly controversial is the level of power and exercised by irrigating interests in both the setting of levels of take out of that system, and also the way in which take has occurred and for what particular industries. The largest single industries that take water out of that system are for cotton production and to some degree rice production and horticultural production. As I understand it, I think in the mid-2000s, more than 90% of the take out of the Barwon, out of the Darling system, was for cotton growing on a very large industrial scale. So those interests are very powerful, and if we, I won't go into the detail of the controversies that have gone on in the system there, but and they're still under judicial proceedings, some of those things in terms of a legal take, or take in excess of what was permitted under licences. There's been controversies over the extent to which those irrigator interests have been an influence over the setting of levels of take, and also taking beyond what they were permitted, that is to say illegally, beyond the limits, or at times they weren't permitted to do so. That has led to some spectacular examples, such as large-scale extraction and virtual emptying of some of those parts of that river system, and also, obviously had very detrimental and profound consequences not only for the environment in that system, but also for downstream users in places like Broken Hill, who have almost run out of water, as I understand it, and also has been particularly significant consequences for the Barka, the Indigenous people on that river, whose existence depends very much on the association with that river, so that death or the compromise of the integrity of that river is very much associated with is detrimentally impairment of their culture. At the federal level, there is also, as is required across the entire Basin Plan system, requirement for the preparation of water resource plans under the Commonwealth Water Act. Now, interestingly, even though water resource plans are required to be prepared and approved by the middle of 2019, there is enormous lag in their preparation at the moment. So there's a number of water resource plans to be prepared that relate to the Darling River system. The one on the Barwon Darling, which is sort of in the middle upper part of that system in central western New South Wales, is intended to reduce take by 6 gigalitres per year. So from 198 gigalitres a year of diversions to 192. The lower Darling also has reductions of take that are going to be required over time. That will be a central feature in many respects of what the Commonwealth Water Resource Plan will require. Now, as I look at doing a bit of research on this today, I see that there's only about 30% confidence at this point in time from the Murray-Darling Basin Authority that this water resource plan will be prepared in a timely manner, that is to say by the required deadline of 2019. So there is quite a significant question mark over that preparation of that water resource plan, and if it is prepared, in some respects over the contents of it perhaps. Further controversies that occurred last year came to light in respect of the Darling, for instance, are around environmental flow rates that were put down that system, and whether they were appropriated or taken out of that system by irrigators downstream. That is to say, whether, we might put it in inverted commas, the environmental flows were stolen, as it were, or whether they were taken unlawfully or so forth. I think that they're probably still the subject to investigation, those questions as well. I think the other thing that's important in both the federal and the state context is that given the significance of the Darling River, in particular to Indigenous people, there is no provision, for instance, for cultural flows or for Indigenous people's direct control or entitlement over water in that system. And that is notwithstanding that there are native title determinations along that system, which relate to land and do not necessarily directly relate to water. So that's, again, creates some kind of anomaly and particular problem for Indigenous people in that system. So that's sort of my overview of water governance in the basin and a bit of a, I guess, a snapshot of how it relates to the Darling system in particular. So I'll leave it at that.
I've just got a couple of questions, Dr. Lindsay. In these water resource plans and water sharing plans being developed by the Commonwealth and various state and territory governments, how much input or say do the local communities have over water extraction?
Well, I guess that's an interesting question and probably depends on who you mean when you refer to community. I think it's probably valuable to consider in water management exercises where various key interests are and what sections of the population are represented by those interests. So you could take economic interests in irrigators and those kind of interests as one section of community. As I said, Indigenous people, I think, have got quite a discrete set of interests and important and powerful set of interests. The public generally, have various interests, I think, in water systems. Public interest ones in environmental health, in having a reasonable water supply, having some kind of industries that relate to water. In terms of rights to participation in those decisions making, there's all sorts of consultation rights, of consultative rights, and more point obligations on governments and water authorities. They exist formally. Substance of them and how effective they are is probably far more questionable. And I think it's useful to consider where the interests lie as well as where formal requirements for participation lie in decision making. That's not to say there aren't avenues for participation by the general community or organised community sectors in policy making and planning and decision making. I think the question is perhaps more over how effective they
are. Dr. Lindsay, you've described a complex and at times contentious governance system through the Commonwealth, state and territory governments. In your expert opinion, does this governance system adequately protect the rights of the Murray-Darling Basin to exist, thrive and evolve?
Well, if you're going to pursue the notion that the system itself is something like a living system, which we have managed to put in legislation down here in Melbourne in the Yarra, for instance, if you take that as an entity in itself, then I think that what we have in terms of Commonwealth legislation, the Water Act and the Basin Plan and so forth, is certainly an improvement on the situation that we had previously. It provides at least legally for caps and controls and obligations in relation to the environmental and the ecological integrity of water systems. Having said that, I think the experience as it's playing out, it probably raises more notes of caution than at least appear in the legislation itself. Part of those notes of caution, I think, concern both the level of caps of extraction that exist in the Murray-Darling Basin and whether they are sufficient or adequate. There's certainly a lot of contention that they haven't been set at the optimal scientific level to protect those systems, as it were, as living entities and protect their integrity, and also, as I indicated, as cultural entities, as places of cultural importance. I think that there are considerable limitations in both in the implementation of those water law regimes as well. That has been most spectacular in terms of what's occurred in New South Wales, in terms of rates of extraction and control over water resources and the detriment to systems like the Darling system. So I think overall it might be considered certainly a step forward in terms of what we have compared to what we had prior to 2007. But I think that there is the need for certainly continued vigilance and I think continued reform of the legal regimes relating to water in those systems in order to, I think, properly recognise and achieve the integrity of those systems, both as ecological entities, as healthy entities in an ecological sense, in a cultural sense, and indeed just in a social sense for those communities who live in that system.
Thank you very much for your time, Dr. Lindsay.
Thank you.